Okay. All right. Iris Merino Portillo,
Sí.
Yes.
What's the name, Your Honor?
it's Marino Portillo, Iris, or Iris. All right. Ms. Merino Portillo, you're charged with battery domestic violence.
Señorita Portillo, a usted se le acusa de violencia física, agresión física de violencia doméstica.
And Mr. Interpreter, we have her with the headphones, so if you want to just establish a connection and let me know.
Thank you, Your Honor.
Sí lo escucho.
Your Honor, the interpreter can confirm that we have connection.
All right, thank you. All right, and the court finds that there's probable cause with respect to that offense. I'm going to appoint the public defender to represent you. In defense with regards to release, do you wish to be heard? It does not appear that she qualifies for PTR.
Your Honor, I would just ask for a $250 bond. It shows that my client has no criminal history and is employed part-time.
All right, I'm going to grant that request. Ms. Marino Portillo, I'm going to set your bond in this case at $250. The conditions of bond is that you not have any contact with the victim. You will not be able to return to the residence, so you have to maintain a separate residence. But I will allow you to return on one occasion, escorted by law enforcement to pick up any personal belongings. All right,
That's fine.
all right, thank you. Antonio Avila? All right, Mr. Avila, you're charged with no valid driver's license. I will appoint the public defender to represent you. With regards to this offense, bond was set at $500. He does not qualify for PTR. Any request defense?
Your Honor, the offer from the state is an adjudication of guilt credit time served if he wants to resolve his case today.
Mr. Avila, the defense stated that the offer to resolve your case would result in a conviction. For this charge, you would get credit for time served, and the court would impose costs associated with this case. Would you like to accept the state's offer?
Para pagar la multa, sí.
To pay a fine, yes.
And you would be convicted on the charge.
No. Yo me declararía culpable.
No. Let me see. I would declare myself guilty.
Okay. So you understand that that would result in a conviction for driving without a valid license?
Sí.
All right,
Yes.
Why don't you take a moment to speak with the public defender with regards to your constitutional rights?
Your Honor, I can't speak any Spanish, but I do have a plea form that is in Spanish, so if he can take the time to review the rights he would be given up on this form.
Is the plea form in Spanish?
Yes, Your Honor.
Okay. So I could turn off the-
It,
Ok, que me dé la oferta a la fiscalía.
Yes, I understand. I will accept it.
Mr. Interpreter, can you please ask the client if he is a United States citizen?
No.
Then
No.
I'm going to recommend that he not accept the state's offer here today until he has a chance to speak with an immigration attorney, because it can subject him to deportation. And Your Honor, I would, since it's not a driving offense, I would ask for I know he doesn't qualify for pretrial release in ROR if you are inclined to grant that. I don't have the information.
All right, Mr. Avila, it appears that because of some immigration consequences, the public defender believes that it would be in your best interest to maybe look into the case further to see what can be done. With regards to this case, as to your release, I'm going to reduce the bond to $100 with the condition that you not drive unless you have a valid driver's license. All right, thank you, sir.
Sí. Oh, thank you.
Thank you.
I don't see one, but.
You have a detainer for immigration? No? Okay.
All right. All right, Jose Osmar Diaz Sanchez.
Sí.
All right, Mr. Sanchez, I'm going to appoint the public defender to represent you. You are charged with driving without a valid driver's license. I do find there's probable cause for this offense. You also have a failure to appear in 2020 MM 4858. And bond in that case is set at $2,000. And on that case, that's for a petty theft charge. Bond will remain as previously set. As to this case, defense, you wish to be heard with regards to release?
Your Honor, I would just ask that you set a $100 bond for the no valid driver's license.
All right, I'll go ahead and reduce the bond to $100. He's not to drive unless he possesses a valid driver's license. 100.
Sí, entendí.
I understand.
All right, Pedro Morales Pascual.
Bando, Your Honor.
All right, he's bonded out. Then we can do these. All right, Jeremiah, are we ready to do the other ones, or Jeremiah Milian? Jeremiah Milian. All right, and you are Jeremiah Milian?
Yes, sir.
All right, Mr. Interpreter, can you just make an announcement to see if there's anybody in the waiting area who needs an interpreter?
Absolutely. Thank you, Your Honor. A todos los presentes que están en la sala de espera, ¿alguno necesita los servicios del intérprete en español? Por favor, levante la mano, preséntese ante el tribunal.
All right, I see no hands. No. All right, thank you.
Thank you, Your Honor. Thank you to the staff.
All right, Mr. Emilian, you're charged with battery on a person 65 years of age or older. You do not qualify for the services of the public defender. I do find there is probable cause with respect to this offense. Bond was previously set at $2,500. With regards to release, you do not qualify for PTR. The court will leave the bond as previously set with the condition that you not return to the scene of the incident, that you not have any contact with the victim, and that you not possess any weapons or any firearms. You were out on bond, or you were out on PTR with regards to 2021 CF 4145. As a result of this new offense, the court will revoke PTR, set no bond. You can ask the judge who's handling your possession case if they consider setting a bond. All right, sir?
So I don't get released today?
You won't be released because of the case that you were on, already on pretrial release. That pretrial release is revoked. So you won't be able to bond out.
So I have to wait till,
You can have your attorney file a motion in your possession case to see if the judge would consider setting a bond.
how long that'll take?
As long as it takes your attorney to get you in front of that judge.
All right.
Taquana Oliver. And you are Miss Oliver?
Yes.
Miss Oliver, you're charged with battery, domestic violence, and this battery by strangulation. The court finds that there is sufficient probable cause with respect to this offense. You do not qualify for the services of the public defender. With regards to release, you do qualify for PTR,
And what's that?
pretrial release.
Okay.
I'm going to release you to pretrial release with the following conditions. You are not to have any contact with the victim. You are to maintain a separate residence. You'll be allowed to return to the residence on one occasion accompanied by law enforcement to pick up any personal belongings. You are not to possess any weapons or firearms. And you are not to consume or possess any alcoholic beverages or drugs or any medications without a valid prescription.
Mhm.
Those would be the conditions of your pretrial release. All right, thank you, ma'am.
When will I be able to get my belongings?
They should be returned to you when you're released. Oh, you mean from the residence?
Yeah.
You'll have to coordinate that with law enforcement so that you can go back and pick up your belongings. You just
Okay.
need to go with law enforcement. You can't go on your own.
No, I know that. I just need to get my stuff today because I got to go to work
You'll
tomorrow.
have to contact them.
Okay. Thank you.
Jamin Orand. All right, Mr. Orand, you're charged with tampering with a witness to hinder communication with law enforcement and battery domestic violence. I will appoint the public defender to represent you. I do find there is probable cause with respect to both of these offenses. And defense with regards to release.
Your Honor, I would just,
Mr. Orand does not qualify for PTR.
Your Honor, I would just ask that you take into consideration that my client is currently unemployed at this time when setting the bond amount in this case.
As to count one, I'm gonna set bond at $1,000. As to count two, I'm gonna set bond at $1,000. The conditions of bond is that he not have any contact with the victim, that he not return to the residence. He'll be allowed to retrieve any personal belongings. If he's accompanied by law enforcement, he'll have one opportunity to do that. He was also out on bond on 2021 CF 752. The court will revoke bond in that case. Mr. Orand, your attorney on that case can file a motion to see if the court will consider resetting a bond, but as of now, you will not have a bond as to your charge of lewd or lascivious battery. Andrew Seymour.
Yes, Your Honor.
Mr. Seymour, you're charged with aggravated assault with a deadly weapon, battery by strangulation, and domestic violence, and battery domestic violence. I will appoint the public defender to represent you. The court finds there's probable cause for all three offenses. Defense, you wish to be heard with regards to release?
Your Honor, I would just ask that you set a reasonable bond in this case. It shows that he has a very limited criminal history, and I ask that you just take that into consideration and the fact that he's lived here in Orange County for over a year, and he's currently employed full-time.
As to count one, the court will set bond at $7,500. As to count two, the court will set bond at $2,500. As to count three, the court will set bond at $1,000. The conditions of bond will be that he have no contact with the victim, that he not return to the scene where this incident occurred. He'll be required to not possess any weapons or any firearms.
Can I speak?
Why don't you talk to your lawyer? All right. Chelsea Smith. All right, Ms. Smith, you're charged with aggravated assault with a motor vehicle. I'm going to appoint the public defender to represent you. I do find there's probable cause with respect to that offense. And she does qualify for PTR. Defense, you wish to be heard with regards to release?
Your Honor, I would just ask that you place my client on pretrial release as she does qualify.
I'm going to release you on pretrial release. The conditions of release will be as follows. You're not to have any contact with the victim. You're to maintain a separate residence. You're not to possess any weapons or firearms. You'll be allowed a one-time return to the residence accompanied by law enforcement to pick up any personal belongings. I'm also going to require that you not possess any drugs or medications without a valid prescription. Thank you, ma'am.
Yeah, I can't. I'll only. No.
Your Honor, my client was just explaining that they both have what I believe is PTS. They have a trial where both of them will be in the same courtroom, so she just wanted to make sure that she would be allowed to go to court.
I don't think that'll be an issue if it's an official court proceeding. You're going to be required to be there. They're going to be required to be there. That won't be an issue.
Okay, I just wanted to make sure that, because like if I'm not there in person, I lose my babies and like.
I understand. Now, this should not prevent you from being able to attend your court proceeding. Do we need to put anything in the notes? Say, no contact other than court proceedings? So I'm going to have the minutes reflect no contact other than court proceedings.
Okay, thank you, Your Honor.
All right, Conroy Smith.
Yes, sir.
All right, Mr. Smith, I'm going to appoint the public defender to represent you. You're charged with tampering with a witness to hinder communication with law enforcement, possession of oxycodone, and domestic violence battery. With regards to these charges, I do find that there's probable cause. We do have a witness with regards to this case. Ma'am, could you say your name?
Tasha McWhorter.
All right, could you raise your right hand to be sworn in?
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
All right, and are you the victim in this case?
Yes. Yes.
All right, and do you wish to have contact with Mr. Smith?
Yes.
Do you have any concerns for your safety if Mr. Smith was released?
No.
If any incident like this occurred again, would you hesitate to call law enforcement?
No.
All right, so if anything like this happened, you'd call the police?
Yes.
Okay. State, any other questions?
No, Your Honor.
Defense, any follow-up?
No, Your Honor.
All right, with regards to release, defense?
Your Honor, I just ask that you take into consideration that the victim did testify that she is not afraid of my client when setting bond in this case. He's only employed part-time, Your Honor, so I just ask that you take that into consideration. And it looks like he has 0 failures to appear, which is an indication that he will in fact show up.
He does have some serious violent history. So as to count one, I'm going to set bond at $1,000. As to count two, I'm going to set bond at $1,000. As to count three, I'm going to set bond at $1,000. The conditions of bond will be as follows. You're not to have any hostile contact with the victim in this case. That means you're not to yell, scream, use profanity towards her.
Yes,
You're not to destroy her property.
Yes,
You're
sir.
especially not to put your hands on her without her permission. Do you understand that?
Yes, sir.
All right. I'm going to require that you not possess any weapons or firearms and that you not possess any drugs or any medications without a valid prescription.
Yes, sir.
All right. Thank you. All right. Denisha Addison.
Yes.
All right. Ms. Addison, I'm going to appoint the public defender to represent you. You're charged with domestic violence battery. I do find that there is a probable cause with respect to that offense. And defense, she does qualify for PTR.
Your Honor, I would just ask that you place my client on pretrial release to show she has no criminal convictions here in Florida.
Ms. Addison, do you live with the victim?
I did. The officers did stay until he was able to take his stuff from my apartment.
You already got your stuff from the apartment?
No. The police stayed until he got his stuff from my apartment.
So he's no longer there?
Correct.
All right. All right. As to this offense, I will release you on PTR. The conditions of PTR is that you not have any contact with the victim and that you not possess any weapons or firearms.
Okay.
All right. Timothy Childs. All right, Mr. Childs, I will appoint the public defender to represent you. You are charged with domestic violence battery. I do find there's probable cause with respect to that offense. He does not qualify for PTR. Do you wish to be heard with regards to release?
Yes, Your Honor, I would ask for a $500 bond in this case. However, I would also ask that you take no action on this out on bond case. But if you are inclined to revoke, that you revoke and set a higher bond as it is a driving offense case. So I would just ask that you take that into consideration.
All right, as to this offense, the court will set bond at $500. The conditions of bond is that you now return to the residence. You'll be able to return on one occasion if escorted by law enforcement to pick up any personal belongings. You have no contact with the victim, and you're not to possess any weapons or firearms.
Yes, sir.
All right, as to 2021 CT 1050, you were out on bond on a driving under the influence charge. The court will revoke the bond in that case. I'll go ahead and set a bond on that, but, so this bond's revoked. I'm gonna set a new bond in the amount of $1,000 with the original conditions.
Thank you.
Angel Ocasio de Jesus. All right, and you are Mr. Ocasio de Jesus?
Yes.
All right, I'm going to appoint the public defender to represent you. You're charged with violating a domestic violence injunction. I do find there's probable cause with respect to that offense. Defense with respect to release, do you wish to be heard? And he does qualify for PTR.
Your Honor, I would just ask that, since my client does qualify, that you place him on pretrial release, in this case. I see that his last conviction was in 2008, Your Honor. And I see 0 failures to appear for court.
All right, Mr. Ocasio de Jesus, I'm going to set bond at $500 with PTR conditions. The conditions of PTR is that you not have any contact, that you abide by the injunction in 2021 DR 328, that you not possess any weapons or firearms, and those are all the conditions. Yes. All right, Cesar Reynoso. Mr. Reynoso, I'm going to appoint the public defender to represent you. You're charged with domestic violence battery. I do find there's probable cause with respect to that offense. You wish to be heard with regards to release. He does qualify for PTR.
Your Honor, I would just ask for pretrial release in this case. My client has 0 criminal convictions, so I just ask that he's placed on pretrial release.
All right, Mr. Reynoso, I'm going to grant that request. I'm going to release you on pretrial release. The conditions of your pretrial release is that you have no contact with the victim. You'll have to maintain a separate residence, but I will allow you to return one time to the residence to pick up any personal belongings, only if you're accompanied by law enforcement. I will also require that you not possess any weapons or firearms. Roberto Rivera.
Yes, sir.
All right, Mr. Rivera, I'm going to appoint the public defender to represent you. You are charged with 2 counts of battery domestic violence. I do find there's probable cause with respect to both of those offenses. The offense you wish to be heard with regards to release, he does not qualify for PTR.
Your Honor, I would just ask for a $500 bond on each count.
All right, I'm going to set bond on count 1 at 500, bond on count 2 at 500 with the following conditions: that you not have any contact with the victim in this case, that you not return to the residence where this occurred. You'll be required to maintain.
Thank you.
Were you living at the residence?
Excuse me, I'm sorry, sir.
Were you living at the residence?
Yes, sir, I live there.
Okay, so you're gonna have to maintain a separate residence. You'll be allowed to return on one occasion accompanied by law enforcement to pick up any personal belongings. And you're not to consume or possess any drugs, alcohol, or any medications without a valid prescription, and you're not to possess any weapons or firearms.
Okay, sir.
All right, Michael Rodriguez.
Yes, sir.
All right, Mr. Rodriguez, I'm going to appoint the public defender to represent you. You are charged with violation of a domestic injunction. I do find that there's probable cause with respect to that offense. You do not, defense, he does not qualify for PTR. Do you wish to be heard with regards to release?
Your Honor, I would just ask that you take into consideration when setting the bond that my client just recently got fired from his job 2 weeks ago. So I just ask that you take that into consideration.
All right. I'm going to set bond at $1,000 on this case. The conditions of bond is that he not have any contact with the victim, that he abide by the injunction in 2020 DR 10934, that he not possess any weapons or firearms. He was out on bond in 2020 CF 12261. The court will revoke bond in that case. So, Mr. Rodriguez, you can contact your lawyer in your burglary of a dwelling with a assault battery therein case, and see if they can file a motion in front of that judge. Oh, there's a second case. Hold on. Oh, okay. Yep. This one. Okay. So there's several. All right. I'm also going to revoke bond in 2020 CF 12263. That's the grand theft charge. So you'll have to have your attorney file a motion with regards to that case. You'll also have a 2021 CT 2681 case. There's a failure to appear for attaching a tag not assigned. Bond on that case was set at $500 and will remain as previously set. Mia Smith. All right, Ms. Smith, I'm going to appoint the public defender to represent you. You're charged with battery domestic violence. I do find that there's probable cause with respect to this offense. And defense, she does qualify for PTR. Do you wish to be heard with regards to release?
Your Honor, I would just ask that you place my client on pretrial release. It does show she has no criminal convictions here in Florida.
All right, with regards to this, I will grant that request. I'll release her to pretrial release with the following conditions. She'll be required to maintain a separate residence. You'll be required not to possess any weapons or any firearms. You'll be allowed to return on one occasion, if escorted by law enforcement, to retrieve any personal items that may still be in the residence. All right. All right, thank you. No contact. No contact with the victim. All right. Ezra Thomas. All right, Mr. Thomas, I'm going to appoint the public defender to represent you. You are currently charged with 2 counts of battery, domestic violence. I do find that there's probable cause with respect to both of those offenses, and we do have a witness. Could you please state your name?
Tamika Thomas.
Could you please raise your right hand to be sworn in?
Do you solemnly swear and affirm the testimony that you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
All right, and Ms. Thomas, you are the victim in this case, is that correct?
Yes.
Do you wish to have contact with Mr. Thomas?
Yes.
Do you have any concerns for your safety if Mr. Thomas were to be released today?
I do not.
If an incident like this occurred again, would you contact law enforcement?
Yes.
All right, state any additional questions?
No, Your Honor.
All right, defense with regards to release?
Your Honor, I would just ask for a $500 bond on both counts. And with the victim's testimony here today stating she is not afraid of my client, I would ask that you set bond at $500 on each count.
All right, I'm going to grant that request. Mr. Thomas, I'm going to set the bond on count 1 at $500, bond on count 2 at $500. The conditions of bond is that you have no hostile contact with Mrs. Thomas. That means that you're not to scream at her, use profanities, destroy her property, and especially not put your hands on her without her permission. You understand that?
Yes, sir.
All right, you're also not going to be able to possess any weapons or any firearms.
Okay.
All right?
Thank you.
All right, thank you. Shirley Velasquez. All right. Ms. Velasquez, I'm going to appoint the public defender to represent you. You're charged with battery, domestic violence. I do find that there's probable cause with respect to that offense. Defense, she does not qualify for PTR. Do you wish to be heard with regards to release?
Your Honor, I would just ask for a $250 bond in this case. My client is currently unemployed, and so I would just ask that you take that into consideration.
Okay. All right. I'm going to set bond at $250 with the following conditions. I'm going to require that you not have any contact with the victim in this case, and that you not possess any weapons or any firearms while out on bond. Were they residing together?
Yes, Your Honor, and I believe he has also been arrested at the same time. They were arrested at the same time.
All right. I'm just going to require that they maintain separate residences.
We're not on any bad terms. He'll tell you that we live together. But we're not, we were never.
This is what I'll do. Can we hold this? Can we hold this one?
Wanna get out.
Just the paperwork. I'm going to take testimony from him. Is he on the docket for today? Is Castillo Mendez here? Castillo, is it Castillo Mendez? I'm sorry, no, Richard Castillo, sorry.
Castillo Cruz?
Yeah.
Richard?
Yeah.
Yep.
Yeah, can we have him?
He's 50.
Can we have him brought out? We can do this one and then we'll call him when it's his turn. I'm just gonna ask him about, I'm just gonna ask him about contact.
Okay. So let me see.
And no, this is all new.
He's got an assault and law enforcement charge, so it's different. All right. Sir, could you please state your name?
Richard Castillo.
All right, Mr. Castillo, do you have any concerns with regards to your safety if Ms. Velasquez was released?
No.
Do you wish to have contact with her?
Excuse me?
Do you wish to have contact with her?
Absolutely.
All right, and if a situation arose where you were possibly the victim of violence, would you contact law enforcement?
Yes.
All right, thank you, sir. We'll call you back when when your case is called up.
Okay, thank you.
All right, so with regards to Ms. Velasquez's case, I'm just going to order that you not have any hostile contact with Mr. Castillo. That means that you're not to scream, use profanity, or destroy his property. You're not to put your hands on him without his permission. And I'm also going to require that you not possess any weapons or firearms. All right? Erica Alfaro.
Medical, Your Honor.
All right, defense, I'm going to appoint the public defender to represent her on this case. Did you want to waive her appearance for the purposes of this hearing?
Yes, Your Honor, I'll waive her appearance.
All right. She has two charges for which she failed to appear. A warrant was issued setting both of those cases with no bond. The court will leave those bonds as set by the court. She also failed to appear in 2020 MM 9210. The bond on that warrant is set at 2,000 and will remain as previously set. All right, Cameron Barnett. Mr. Barnett, I'm going to appoint the public defender to represent you. You're charged with possession of ammunition by a convicted felon, possession of methamphetamine, and possession of drug paraphernalia. He does not qualify for PTR. Defense, do you wish to be heard with regards to release?
Yes, Your Honor, I would just ask that on count one, you consider reducing the bond amount. My client is on Social Security disability, so I would just ask that you take that into consideration and the fact that on his out-on bond case, he could not afford that bond as well, so he had to wait 13 days, 13-day motion was granted. That's when he was released. So I ask that all of that into consideration with that bond.
All right. As to this case, the court will set bond on count one at 2,500. Counts 2 and 3 will remain as previously said. The conditions of bond is that the defendant not possess any drugs, alcohol, or any medications without a valid prescription, that he not possess any weapons, firearms, or ammunition, that he not return to the scene where this incident occurred. And and those are all the conditions for that case. With regards to 2021 CF 2453, the court will revoke ROR, set no bond. Mr. Barnett, you can ask your attorney who's handling that case to see if the judge will consider setting a bond. All right, William Bonilla Cruz. Mr. Cruz, I'm going to appoint the public defender to represent you. You're charged with destruction of evidence, possession of methamphetamine, possession of drug paraphernalia, and resisting an officer without violence. Defense, he does not qualify for PTR. What would you like to argue with respect to release?
Your Honor, I would just ask that on counts 1 and 2, you consider reducing the bond amounts. My client is currently unemployed, and he doesn't have any current family here that can assist him with paying the amount.
All right, as to count 1, I'm going to leave that charge, the bond as previously set. As to count 2, I will reduce to 500. As to count 3, I will reduce to 100. As to count 4, I will leave as previously set. The court will require that you not possess or consume any drugs or any medications without a valid prescription. I'm also going to require that you not possess any weapons or firearms.
Illegally did something, and I shouldn't be here right now because it was illegal, and it's in my right.
I understand, sir, and your
I should
attorney,
be released right now. If you guys will watch that body cam, I will be released right now.
your attorney can file the appropriate motion, okay?
I can't afford that shit.
All right, Josiah Brooks. All right. Did Josiah Brooks bond out?
Yes, Your Honor.
Okay. Daniel Brown?
Caballero.
Okay, did Brown bond out?
Bonded out.
All right. Do you know if Daniel Brown bonded out?
Bonded out.
All right, thank you. Yasmani Caballero? Mr. Caballero, I'm going to appoint the public defender to represent you. You're currently charged with burglary of a dwelling and grand theft of a dwelling, $100 or more. As to those two counts, I do find there's probable cause. Defense, you wish to be heard with respect to release?
No, Your Honor.
All right, as to those counts, the court will leave the bonds as previously set. Bond one will remain set at 5,000, count two will remain set at 1,000. The conditions of release will be that he not return to the scene where this incident occurred, no contact with the victims, and no weapons or firearms. You were out on bond in 2019 CF 15959. With respect to those charges, the court will revoke bond. Mr. Caballero, you can request that your attorney on that case file a motion before the judge who has that case to see if that judge will consider setting a bond, okay? All right. Edwin Castillo Cruz. All right. Mr. Castillo Cruz, I'm going to appoint the public defender to represent you. I do find that there's probable cause with respect to counts 1 and 2, grand theft of a motor vehicle and resisting an officer without violence. As to the issue of bond, Mr. Castillo Cruz does not qualify for PTR. Do you wish to be heard with regards to release?
Your Honor, only on the out on bond case, I would ask that you, if you are inclined to revoke, you revoke and set a higher bond. They are nonviolent offenses, so I'd ask that you take that into consideration and the fact that my client is employed part-time. So I ask that you take that into consideration before revoking the bond amount.
All right, as to this case, the court will leave bond as previously set. I'm going to require that you not return to the scene where this incident occurred, that you not have any contact with the victim, and that you not possess any weapons or firearms. As to the 2021 CF 4285, I am going to revoke the bond, but I will set new bonds. As to count 1, in that case, will be set at 1,000. As to count 2, it'll be set at 500. And as to count 3, what did I say for count 1? I already forgot.
1,000.
1,000, count 2, 500, and count 3 will be 500. And he's not to possess any drugs or alcohol. All right, Jamie Chapman.
Yes, sir.
All right, Mr. Chapman, I'm going to appoint the public defender to represent you. You are charged with burglary of a structure and possession of drug paraphernalia. The court finds that there's probable cause for both of these offenses. It does not appear that he qualifies for PTR. Do you wish to be heard with regards to release defense?
Yes, Your Honor, I would just ask that you consider reducing count 1. My client is currently unemployed. However, I see the last conviction was in 2018, so I ask that you take that into consideration when setting the bond amounts in this case.
All right. As to count 1, I'll reduce it to 2,500. Count 2, I'll reduce to $100. The conditions of bond is that you not return to the scene where this incident occurred, that you not possess any drugs or any medications without a valid prescriptions, and that you not possess any weapons or firearms.
Yes, sir.
All right, Benny Edwards.
Sir.
All right, Mr. Edwards, you're charged with burglary of a structure. I'm going to appoint the public defender to represent you. I do find there is probable cause with respect to that offense. And do you wish to be heard with respect to release?
Your Honor, no, I have no argument as far as release.
All right, I'm going to leave the bond as previously set. I'm going to require the following conditions. Mr. Edwards, you're not to return to the scene where this incident occurred. You're not to have any contact with the victims, and you're not to possess any weapons or firearms. Kendrick Hart.
Yes, sir.
All right, Mr. Hart, I'm going to appoint the public defender to represent you. You're currently charged with possession of MDMA, 2 counts of possession of MDMA, 1 count of possession of cannabis, and 1 count of possession of drug paraphernalia. And I do find there's probable cause with respect to all of these offenses. As to 2021 CT 2244, you're charged with failing to appear, or there's a warrant issued for your failure to appear. Bond in that case was set at 500. The court will set the bond as previously set, so it will remain as previously set on that case. As to 2021 CT 2243, there was a warrant for your arrest for failing to appear on that case. Bond was set on that warrant at 1,500 and will remain as previously set. As to this case, defense, you wish to be heard with regards to release?
In this case, my client is employed full-time, however, with all the other bond amounts that he has to post, it'd be kind of hard to afford all of those bonds.
So they had set it at 15,000?
Yeah.
Okay, so, actually, the bond on count 1 was set at 15,000. Count 2 was set at 1,000, count 3 at 500, and count 4 at 500. So there was apparently a bond correction with respect to that. As to this, the court will set bond on count 1 at 7,500, bond on count 2 at 1,000, bond on count 3 at 100, and bond on count 4 at 100. The conditions of bond is that you not return to the scene where this incident occurred, that you not possess or consume any drugs or medications without a valid prescription. You're not to possess any weapons or firearms. He was out on bond on 2021 CF 3144. That was a driving as a habitual traffic offender and resisting without violence. I'm going to revoke the bond in that case. Mr. Hart, you can request that your attorney file a motion in front of that judge to see if the judge would consider resetting a bond in that case.
Judge, please. It's my birthday today, please.
All right, sir. Well, you're out on bond. You committed a new offense, so the court's revoking your bond. If that judge wants to set a new bond, you can file that motion in front of them. Yes, please. And the PD is appointed on that case as well. Richard Herbert, do we need to take a break? All right. Defense, do you wish to waive his appearance for the purposes of this hearing?
Yes, Your Honor. Well, I'll waive his appearance. Your Honor, I did have a PC challenge.
All right, go ahead.
On the use of an anti-shoplifting device. In the arrest affidavit, it does state that he used foil. It didn't state that, it just stated that he used foil to wrap around items and take them out. The court has stated that an anti-shoplifting or inventory control countermeasure is any item or device designed, manufactured, modified, or altered to defeat any anti-shoplifting or inventory control device. And they have stated that foil alone is not an item that can be used by itself to be considered an anti-shoplifting device. When used in a bag surrounded with foil, at that point it is an anti-shoplifting device, but aluminum foil alone is not considered an anti-shoplifting device.
State response.
One moment, Your Honor. Yes, Your Honor. It appears that the defendant in this case used the tinfoil in conjunction with tweezers, and it looks like it is the tactic that she was describing where it involves some sort of bag, but it does not make mention of whether or not he used some sort of bag in conjunction with the foil. The state would just argue that there is probable cause as to that charge.
I mean, and I understand the defense's argument that if they were just in the store with foil, that would not be it. But this here, they were using the foil, wrapping the devices with the foil. So that's modifying the device. It's not like they just innocently had foil in their possession. So I'm going to find that there's PCS to both of these charges. With regards to release, the court will leave bond as previously set. The conditions are that they not return to the scene where this incident occurred, they not possess any weapons or firearms. As to, there were two other cases in which the defendant was out on bond. In 2020 CF 13959, the court will revoke bond. In 2021 MM 1985, the court will revoke bond in that case. Yeah, there were two. All right. Jamie Huffwedemeyer?
Huffwedemeyer, my maiden name and my married name.
Right, Huffwedemeyer. All right. Ms. Huffwedemeyer, I'm going to appoint the public defender to represent you. With regards to, you have two charges. One is possession of methamphetamine. I do find there's probable cause with respect to that offense. With regards to the other case, which is a grand theft of a motor vehicle,
Yeah, it should not even been a report.
at this point, based on the report, the court will find probable cause as to that offense. It does not appear that Ms. Huff-Wiedemeyer is eligible for pretrial release. Do you wish to be heard with regards to bond defense?
Yes, Your Honor, I would just ask that you consider lowering the $1,000 bonds in this case. My client did state she cannot afford a $1,000 bond. She's currently unemployed at this time. And I do see that her last full year of here was in 2007, which, and her last conviction was in 2016. So I ask that you take both into consideration.
All right, as to 2021 CF 5037, the court will set bond at $500, reduce it to $500. The conditions is that you not possess or consume any drugs or any medications without a valid prescription. As to 2021 CF 5031, the court will leave the bond as previously set. Conditions are that she not possess any weapons or firearms, and that she not have any contact with the victim if the owner of the vehicle is known.
Honor, do you have the name? No contact with the victim?
What victim?
The owner of the stolen vehicle, if you know who that is.
It was not stolen. He let me use it to transform my clothes.
Okay, which is, I understand, but at this point, the car was reported stolen, so you're not to have any contact with that person.
I can't have contact. I need my things.
I thought we already call this one? Because I don't have? Okay. I do. Okay. Maybe it was Osceola and then they brought him here. Okay. Joshua Jagatka? He bond out?
No, without
His- It's 210-10272.
72?
Mhm. All right, Jeremiah Jones.
What's up?
All right, Mr. Jones. I'm going to appoint the public defender to represent you.
Yes, sir.
You're charged with aggravated fleeing and eluding with injury or damage, reckless driving, and no valid driver's license.
So when these
I
charges
do-
came upon, because I don't see none of these charges on none of my affidavit papers.
Your Honor,
I'm going to appoint the public defender to represent you. Defense?
Your Honor, I believe these are add-on charges. He was seen yesterday.
Yeah.
So I ask that you take that into consideration. I believe one of his bond amounts were $20,000 for I think it was the carjacking. So I ask that you take that into consideration when setting the bonds in these cases, as he already has a high bond and is not currently working.
All right. As to count 1, the court will set bond at $10,000. As to counts 2 and 3, the bonds will remain as previously set. The conditions of bond is that you not drive unless you have a valid driver's license and that you not possess any weapons or firearms. Arthur Lipscombe. All right, Mr. Lipscombe, I'm going to appoint the public defender to represent you. You're charged with burglary of a structure. I do find that there's probable cause for that offense. And he doesn't qualify for the services of the public defender.
Okay.
Mr. Lipscombe, you make $1,100 weekly, every week? Okay. All right, you're not going to qualify for the services of the public defender. As to your charges, I'm going to leave the bond as currently set. Actually, let me see here. No, you qualify for PTR. I'm going to release you to PTR. The conditions of your PTR will be as follows. You're not to have any contact with the victim or any co-defendants. You're not to return to the scene where this incident occurred, and you're not to possess any weapons or firearms, okay? All right, thank you, sir. Daniel Mancilla Perea.
Daniel Mancilla Perea.
All right. Mr. Mancilla Perea, you're charged with resisting an officer with violence, resisting without violence, trespass on property after warning, and resisting an officer with violence and resisting an officer without violence. Defense, you wish to be heard? All right, I do find there's probable cause with respect to these offenses. It appears there was 2 incidents that occurred. One was at the scene and the other one was while he was in the back of the squad car. Do you wish to be heard with regards to release? He is eligible for PTR.
Yes, Your Honor, I would just ask that he's placed on pretrial release in this case.
All right, I'm going to grant that request. Mr. Mancilla Perea, you will be released on pretrial release. The conditions of release is that you not possess any weapons or firearms. And this occurred at the Marriott Grand Vista. So you'll not be allowed to return to that location. And you're not to possess or consume any drugs, alcohol, or any medications without a valid prescription.
Your Honor, I believe his items are still in the hotel. Would he be able to have a one-time return with law enforcement to get his belongings?
Yes, he can have a one-time return to the property. All right, Brian Matuda. Mr. Matuda, I'm going to appoint the public defender to represent you. You're-
Oh, this is Craig.
I'm sorry, are you not Mr. Matuda?
It's not another docket.
Yeah, it's 210-10273. All right. Mr. McCray? All right, Eric McCray, I'm going to appoint the public defender to represent you. You're charged with aggravated assault with a deadly weapon. Bond was set at $2,500. He does not qualify for PTR. Defense, do you wish to be heard with respect to release?
Your Honor, my client is currently unemployed. He cannot afford A $25,000 bond. I do see.
It's 2,500.
I'm sorry?
2,500.
A $2,500 bond. Your Honor, would you be inclined to reduce that bond amount to $2,000 in this case? I see here he has no convictions, but he is currently transient, Your Honor. I'm sorry, it showed that, on my form, it shows he was not interviewed for pretrial release. He was placed in safe. So can he be interviewed for pretrial release? To see if he can qualify, Your Honor, and then if he does not qualify, the alternative is to have a monetary bond set. Because he wasn't given a chance to interview with pretrial release to see if he would qualify. That would be another way to lower his bond amount if we placed him on pretrial release. And
It looks like he's previously been held as a violent offender of special concern. I don't think he's going to qualify.
oh, okay. Okay, Your Honor.
All right. The court will leave the bond as previously set with the conditions that he now return to the intersection of East Church Street and South Roslyn Avenue. I'm going to require that he not have any contact with the victim and that he not possess any weapons or any firearms. All right, Ronald McIntosh.
Yes, sir, Your Honor.
All right, Mr. McIntosh, I'm going to appoint the public defender to represent you. You're- Huh? Yeah. You're charged with aggravated assault with a firearm, possession of ammunition by a convicted felon, and possession of MDMA. And I'm appointing the public defender to represent you. I do find there's probable cause for all three of these offenses. Defense, you wish to be heard with regards to release?
Yes, Your Honor. I just ask that you consider the fact that my client's unemployed and that his last conviction here was in 2009 for driving while license suspended. So I ask that you take that into consideration when setting the bond amount for the aggravated assault with the firearm.
I'm going to set bond on count one at $10,000. Count two and count three will remain as previously set. The conditions of bond will be as follows. You're not to have any contact with the victims in this case. You're not to possess any weapons or any firearms. You can't hear me?
No, Your
we
Honor,
can't
I'm
understand you.
sorry. He could not hear.
Do you need a headset or can you hear me now?
I can hear you now.
Oh, okay, all right. As to count one, I'm going to set bond at $10,000. Counts two and three will remain as previously set at $150. The conditions of bond will be that you not have any contact with the victim, that you not possess any weapons or any firearms, and that you
I wish we could talk to him. Wish we could.
and that you not possess any drugs or any medications without a valid prescription. James Miller.
Yes, sir.
All right, Mr. Miller, I'm going to appoint the public defender to represent you. You're charged with possession of cocaine. I'm going to find that there's probable cause with respect to that offense. Defense, you wish to be heard with regards to release?
Your Honor, I would just ask that you reduce the bond amount to $500. It shows that he's working, but my client just stated that he is not currently working at this time. So I just ask that you reduce the bond amount.
I'm going to grant that request. I'm going to set bond at $500. Condition of bond is that you not possess or consume any drugs or any medications without a valid prescription. Jaden Richardson.
Sir.
Mr. Richardson, you're charged with carrying concealed firearm. You do not qualify for the services of the public defender. Is it correct that you make $700 a week?
Yes.
Okay. All right, so you're not going to qualify. As to this offense, you do qualify for pretrial release. So I'm going to release you on pretrial release. The condition will be that you not possess any firearms or any weapons while out on bond.
All right.
All right, and that's the only condition. Michael Simmons.
Bond, Your Honor.
George Smith.
Sir.
All right, Mr. Smith, I'm going to appoint the public defender to represent you in this case. Currently, you're charged with, in 2021 CF 5045, trafficking in cocaine, more than 28 grams, and possession of drug paraphernalia used to transport drugs. In 2021 CT 3230, you're charged with driving while license suspended. I do find that there's probable cause for both of these offenses. Defense, you wish to be heard with regards to bond in either of those cases?
Your Honor, I would just ask that you consider reducing the bond amount on count one. I know my client is employed full-time, however, it's a $50,000 bond, and he does have other out-on-bond cases that he has had to post bond for. So I ask that you take that into consideration when setting his bond amount in this case.
All right. As to the 2021 CF 5045, I'll set bond at $25,000. As to count two, bond will remain as previously set at $2,500. Conditions of bond is that you not possess any drugs or any medications without a valid prescription. As to 21 CT 3230, bond will remain as previously set, condition that he not drive without a valid driver's license. Now, you were out on bond, Mr. Smith, in 2020 CF 7419. Those were the identical charges to what you're charged with in this new case. The court's going to revoke the bond in that case. You can have your attorney in that case file a motion in front of the judge handling that case to see if they'll considering setting a new bond. Oh, and you were also out on bond in 2020 CF 3513. And is that an Osceola case? Yes. All right. And the court's going to revoke the bond in that case as well. Your attorney can file a motion in front of that judge to see if that judge will consider setting a bond. All right. Robert Spencer.
Yes, sir.
All right, Mr. Spencer, you're charged with possession of cocaine with a weapon and possession of a weapon by a convicted felon. This was pursuant to an arrest warrant issued by a judge in this circuit having already found probable cause. He is not eligible for PTR. Defense, you wish to be heard with regards to release?
Your Honor, as his out-on-bond charge, I would just ask that you not revoke and set at none. I think it's a driving while license suspended in the possession of a controlled substance. So if you are inclined to revoke, that you revoke and set a higher bond in that case, as opposed to setting it at none.
As to 21 CF 5053, the court will leave the bond as previously set, with the conditions of bond that you not possess any weapons or any firearms, and that you not possess any drugs or any medications without a valid prescription. As to 2020 CF 13264, the court will revoke bond. Mr. Spencer, you can ask your attorney who's handling that case to file a motion in front of that judge to see if they'll consider setting a new bond. All right, Danielle Thomas.
Refuse, Your Honor.
All right, I'm going to appoint the public defender to represent Ms. Thomas. She was, defense, are you waiving her appearance?
Yes, Your Honor, I'll waive her appearance.
All right, in 2020 CF 10379, she failed to appear. A bond was issued, setting no bond on that case. That will remain as previously set. She's been charged in 2021 MM2925 with possession of drug paraphernalia. I do find there's probable cause with respect to that offense. Do you wish to be heard with regards to release on that charge?
No, Your Honor.
All right, bond will remain as previously set with the condition that she not consume or possess any drugs or any medications without a valid prescription. As to her cases, she was out on bond in 2021, CF 4536. The court will revoke bond in that case. And she was also out on bond in 2020, CF 15050. And the court will revoke bond in that case. All right. PD appointed on the revocation cases. All right. Alejandra Velasquez. It's 210-10262. Yeah. Joe Wilson. All right. I'm going to appoint the public defender to represent Mr. Wilson. And defense, do you waive his appearance for the purposes of this hearing?
Yes, Your Honor, I'll waive his appearance.
All right. Mr. Wilson is charged with battery on law enforcement, assault on law enforcement, intimidation, threats, or serious bodily harm to family members of law enforcement, trespass on property after warning. The court finds there's probable cause as to all of these offenses. There was a correction as to count one. It was originally set at 2,500, not 1,500. Do you wish to be heard with regards to release?
No, Your Honor.
All right, the bonds will remain as previously set, 2,500 on count one, 150 on counts 2, 3, and 4. The conditions of bond is that he not possess any weapons or any firearms and that he not return to the scene of the incident. He was out on bond on two cases. First, in 2021, MM 2783. The court will revoke bond on that case. He was also out on bond in 2021, MM 2784. The court will revoke bond on that case as well. The PD will be appointed on those cases. Eduardo Alvarez. All right, Mr. Alvarez, I'm going to appoint the public defender to represent you. There was a warrant for your arrest based on a failure to appear in a battery case. That was in 2020 MM 311. Defense, the court will leave the bond as set. Mr. Alvarez, you can request that your attorney file a motion in front of the judge handling that case if you can't afford that bond, but the bond is set at 2,000. All right, Fatima Corderubi. Fatima Corderubi.
Bonded.
Bonded, okay. All right. Bryant Martinez. All right, Mr. Martinez. I don't have a PTR sheet for him. Does he qualify? Yeah. He's already bonded out? All right.
Yeah, I don't have him. Yeah, I don't have him.
All right.
His booking number is 210102991.
All right, well, I'll just appoint the public defender and leave the bond as set. If there's any issue, since he's already posted bond. Martinez. Lonnie Melvin.
Sir.
All right, Mr. Melvin, I'm going to appoint the public defender to represent you. You're charged with one count of no valid driver's license in 2021 CT 3226. You're also charged with resisting an officer without violence in 2021 MM 2937. I find that there's probable cause as to both of these offenses. In the 2021 CT case, CT 3226, bond was set at $500. And in the resisting without violence case, bond was set at $500. Defense, you wish to be heard with regards to release. He does not qualify for PTR.
Yes, Your Honor, the offer from the state was withhold credit time served. And my client wants to accept the state offer.
On both cases,
Did I do it right? Or was it? That's what I wrote down. I just want to make sure. Okay. Yes, Your Honor.
on both cases, on the resisting without violence and the no valid driver's license?
Just the no valid. I need to make sure.
As long as there's an NTA on the resisting, you should be good, right?
Yeah. He wants to resolve both today, Your Honor.
All right, and state your offers of withhold and credit time served.
Yes, Your Honor.
All right, and Mr. Melvin, do you want to resolve your cases today?
Yes, sir.
All right, and you understand that so let me have you raise your right hand and be sworn in.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, to help you God?
Yes, ma'am.
Thank you.
All right, and just state your name for the record.
Lonnie Edwin Melvin,
And what's your date of birth?
12892.
Are you under the influence of any drugs, alcohol, or medication at this time?
No, sir.
Are you suffering from any mental illness or emotional disturbance?
No, sir.
How far did you go in school?
10th grade.
And do you read and write in English?
Yes, sir.
And did you have a chance to read and review the constitutional rights in your plea forms?
Yes, sir.
All right. Do you understand that by entering this plea, there will be no trial and I will impose sentence based upon the plea agreement?
Yes, sir.
And do you understand that by entering this plea, you're waiving or giving up all of the constitutional rights contained in that plea form?
Yes, sir.
Have you had enough time to discuss with your attorney your case and your decision to plea?
Yes, sir.
Do you need any additional time?
No, sir.
Do you understand that if you are not a United States citizen, that entry of this plea would result in deportation?
Yes, sir.
Do you understand that if you've been convicted of a sexually motivated or sexually violent offense, or if you were pleading to any such offense today, that entry of this plea would subject you to involuntary civil commitment as a sexually violent offender upon completion of your sentence?
Yes, sir.
All right. And as to 2021 CT 3226, how do you plead to the charge of no valid driver's license?
No contest.
As to 2021 MM 2937, how do you plead to the charge of resisting without violence?
No contest.
All right. As to as to both cases, I will find that you're alert and intelligent, that you understand the nature of the charges and are represented by competent counsel with whom you say you are satisfied and who you say you've had enough time to discuss this decision with. I will therefore accept your plea. I find there's a factual basis based on the arrest affidavit submitted by Officer Justin Brood. As to 2021 CT 3226, the court will withhold adjudication, sentence you to 2 days credit time served, and I will impose court costs. As to 2021 MM 2937, I will withhold adjudication, sentence you to 2 days with 2 days of credit time served. Will impose court costs. All court costs will be reduced to a civil judgment. All right, Mr. Melvin, you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you.
Yes, sir.
All right, Gene St. Charles. All right, Mr. St. Charles, I'm going to appoint the public defender to represent you. You're currently charged with possession of cannabis, less than 20 grams, and possession of drug paraphernalia. It appears that he does not qualify for PTR. He also has a failure to appear for. He was ROR'd on those two charges? Okay, yeah, I was going to say it said ROR there, yeah. But he does have a failure to appear in 2021 CT 678. So that case is still pending, Mr. St. Charles, but the judge in that case issued a warrant, but ROR'd you upon being picked up for that warrant. As to this case, Defense, do you wish to be heard with regards to release?
Yes, Your Honor, I would just ask, normally on the possession of cannabis and drug paraphernalia, the state usually, no process these charges. And because of that, I would just ask for ROR. My client can't afford a bond right now. He's just started a job. He's actually supposed to start today. So I just ask that you take that into consideration and release him on ROR,
State?
on those two charges.
No objection.
All right. Mr. St. Charles, I'm going to grant your defense attorney's request. I'm going to ROR you on counts 1 and 2. Just keep in mind that you will be required to appear for court. Just because we're RORing you doesn't mean the case is closed.
Yeah, I could say something.
Talk to your lawyer first.
Thank you, Your Honor.
You're welcome. Ishmael Alexander Porter. Mr. Porter, I'm going to appoint the public defender to represent you. You're charged with trespass on property after warning. I do find that there's probable cause for that offense. Defense, what would you like to do with regards to this case? Are we going to resolve this one?
Just a second. Your Honor, the offer from the state is a withhold credit time served with trespass after a warning. My client would like to accept the state's offer here today. I would just ask that because he's resolving the trespass, that you take no action on the petty theft that he is currently out on ROR for.
All right. All right, Mr. Alexander Porter, do you want to raise your hand to be sworn in?
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? Thank you.
All right. And could you just state your full name and date of birth?
11/20/1996, Ishmael Alexander Porter.
All right. And Mr. Porter, you want to enter a plea today, is that right?
Yes.
All right. Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Are you suffering from any mental illness or emotional disturbance?
No, sir.
How far did you go in school?
11th grade.
And do you read and write in English?
Yes, sir.
And did you read and understand the constitutional rights in your plea form?
Yes, sir.
And do you understand that by entering this plea, you're giving up those constitutional rights?
Yes, sir.
Do you understand that by entering this plea, there will be no trial, and I will impose sentence based upon the plea agreement?
Yes, sir.
Have you had enough time to discuss this decision with your attorney?
Yes, sir.
And are you sure that you want to enter a plea today?
Yes, sir.
All right. Do you understand that if you are not a United States citizen, that entry of this plea will result in deportation?
Okay.
I'm sorry?
Yes, sir.
And do you understand that if you are pleading to a sexually motivated or sexually violent offense, or if you've previously been convicted of any such offense, that entry of this plea would subject you to involuntary civil commitment as a sexually violent offender upon completion of your sentence?
Yes, sir.
All right. With regards to this charge, trespass on property after warning, how do you plead?
No contest.
And are you entering that plea because you believe it's in your best interest?
Yes, sir.
All right. I will therefore accept this plea. I find that you are alert and intelligent, that you understand the nature of the offense, and have an opportunity to consult with competent counsel. I do find there's a factual basis based on the report of Officer Eric Adler. I therefore will proceed with sentencing. As to this count, I will adjudicate you guilty. I will sentence you to 2 days in the Orange County Jail. Was it an adjudication?
It was a withhold.
I apologize. I'm sorry. I will withhold adjudication, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs and reduce those court costs to a civil judgment. Anything additional, defense?
No, Your Honor.
All right. Mr. Alexander Porter, you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing and must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed for you. I'm not going to take any action on the petty theft for which he was currently out on ROR. Richard Castillo. And Mr. Castillo, you make $1,200 every week, is that right?
Yes, sir.
All right, you're not going to qualify for the services of the public defender. And you do not qualify for pretrial release. As to this offense, you're charged with assault, which is a second-degree misdemeanor. Okay. I do find there's probable cause with regards to that offense. As to the assault charge, the court will leave the bond as previously set at $250. Conditions are that you not possess any weapons or any firearms. You were out on bond in 2021 CF 1910. Because of this offense, the court will revoke the bond in that case. You can request that your lawyer on that case ask the judge who's handling that case to set a new bond. All right, thank you, sir. Nelson Figueroa.
Behavior, Your Honor.
All right, I'm going to appoint the public defender to represent Mr. Figueroa. Defense, you waive his appearance.
Yes, Your Honor. I'll waive his appearance.
All right, Mr. Figueroa is charged with criminal mischief and resisting an officer without violence. I do find there's probable cause with respect to that offense. With regards to release, the court will leave the bond as previously set with the condition that he not return to the scene where this incident occurred, that he not have any contact with the victim, and that he not possess any weapons or any firearms. All right, Jacqueline Lasseri.
Yes.
All right, Ms. Lasseri, I'm going to appoint the public defender to represent you. You've been charged with battery. I do find that there's probable cause with respect to that offense. Defense, you wish to be heard with regards to release. She does not qualify for PTR.
Your Honor, it seems that she wasn't interviewed for pretrial release. So I would just ask that she be interviewed, and if she does qualify, she's placed on pretrial release. I don't see any type of criminal history listed on this form. However, in the alternative, I would just ask that you set a below bond in the chance that she does not qualify for pretrial release.
I only get a check, Your Honor, and I'm homeless, and I could have made it to my apartment, and I wasn't, and I didn't even. I need a goddamn cigarette.
All right. As to this charge, the court will set the bond at $250 with a condition that she not return to the scene where this incident occurred, and that she not have any contact with the victim. She's not to possess any weapons. That's what the bond will be set at. If she doesn't qualify for PTR, she can be re-interviewed for PTR, but if she doesn't qualify, that will be the bond amount and the conditions.
Okay, but.
So, Ms. Lasseri, if you don't cooperate with pretrial release, you're just going to have to set a bond, okay?
No, I'm gonna cooperate with pretrial release.
Thank you.
We'll win.
They're gonna speak with you.
Patrick Welsh.
Bond, Your Honor.
All right. Jomar Atencio. All right, Mr. Atencio, I'm going to appoint the public defender to represent you. These are out-of-county warrants from Lake County. Both warrants have bonds set. Each count is set at $2,500. If you can't afford that bond, you're going to have to wait till you get to Lake County or have your attorney file a motion before the judge to see if you'd be willing to reduce those amounts. Yes, sir.
So can I get bonded out from here?
Should be able to, there's a bond set on your warrant.
Okay.
Okay, you have a bond. All right, thank you, sir. William Brainard,
Brainerd, yes, sir.
Brainerd, I'm sorry. Mr. Brainerd, I'm going to appoint the public defender to represent you. You have out-of-county warrants. These are from Indian River County. The judge in that case set those bonds at no bond. So you'll have to wait till you get to Indian River County to request that that judge consider setting a bond in your cases. But you don't currently have a bond now, so you can't bond out.
Right.
Okay?
Is there like a time frame for them to come get me? Do they have a limit, 30 days or something?
You're going to have to talk to your lawyer about that. I've appointed the public defender to represent you. But you're going to have to talk to your lawyer about that in Indian River County to see what they can do about getting you over there. Rafael Rodriguez Restrepo. All right. I'm going to appoint the public defender to represent you. This is an out-of-county warrant out of Osceola County. The bond was set at no bond. So you're going to have to wait till you go to first appearance in Osceola County for the judge there to consider setting a bond. At this time, I'm not able to set a bond on that warrant. I can't modify the bond. They're going to have to wait till they go to Osceola on that one. Can I set it from here?
When? Wednesday.
I've never seen it done. I'm going to leave it as it is. You're going to have to wait till you get to Osceola County for them to set the bond. They'll probably have you brought over there tomorrow. Okay. I did. Gardner is next, yeah. I just didn't have this form for him, so I thought I'd gotten them out of order. Rodkeem Gardner. He bonded out? Okay. Rhonda Vander. All right, Ms. Vander, you have an out-of-county warrant from Polk County. The judge on that warrant did not set a bond, so you're going to have to wait till you get to Polk County, or you can have your attorney here, or your attorney there file a motion to see if the judge over there would consider setting a bond in your case, okay?
Yeah.
All right. Devon White.
Mental health, Your Honor.
All right, I'm going to appoint the public defender to represent Mr. White. Defense, do you waive his appearance for the purposes of this hearing?
Yes, Your Honor.
All right, Mr. White has out-of-county warrants from Osceola County. There's 2 counts, neither have bonds set, so the court will just leave those as previously said in the warrant, and they can be addressed in Osceola County. Oh, he's got another case? Hold on. Sorry. All right, he also has 20 CF 2504 out of Osceola County. No bonds were set on those warrants as well. Those will remain as set. And I think, is that it? Oh, okay, yeah, yep, I see them now. Okay, all right. Yep, okay. All right. He also has an out-of-county warrant in 18 CF 4416. Those counts have no bond and will remain as set. He has out-of-county warrant from Osceola in 18 CF 1514. No bond was set in both of those counts. Those will remain as set. He has an out-of-county warrant for 17 CF 3668. No bond was set in those cases. Those will remain as set. He has an out-of-county warrant in 18 CF 4414. There are 3 counts, no bond was set in either of those counts that will remain as set. And then he's got 2018 CF 4415. There's an out-of-county warrant, and he had 5 counts in that for which no bond was set on each count. That will remain as set. Those are all out of Osceola County. All right, Sean Michael Perry.
Sir.
All right, Mr. Perry, I'm going to appoint the public defender to represent you. With regards to this offense, this was a charge of possession of cocaine and charge of possession of drug paraphernalia. Bond was set at $1,100. And there was also an order revoking the defendant's bond in 2021 CF 1594. The offense you wish to be heard with regards to release? Yes. Yes.
He's here only for the case, 2021 CF 001594. He was charged with possession of fentanyl and cocaine. The state didn't, file on the fentanyl charge. He was here yesterday.
Okay.
So it was a bond for the fentanyl charge, so we just letting you know that. Huh? I didn't hear you. What's the case number? It's, 2021 CF 001594. That's what I was talking to you about.
So with regards to count 1, the court will delete that bond and only be required to bond out on count 2.
Okay, so he only bonded out on count 2, we're gonna delete count 1.
Yeah. On the revocation.
He only has 1 bond for count 2, set it out.
Yeah.
So the fentanyl charge is gonna be,
We're going to delete that bond since they didn't file on it.
He's deleting count 1, and he's setting bond on count 2, that's out.
okay, that's the cocaine.
Is that what we're supposed to?
Well, we got the cocaine charge,
Which count did they not file on?
2, the fentanyl.
So you're just setting count 1.
All right, then count 2 will be deleted. All right, thank you, sir. Sean Michael Davis.
Yesterday I came. This, so. So I still can't get out.
All right, Mr. Davis, I'm going to appoint the public defender to represent you. In defense, he's charged with disorderly conduct. Are we trying to resolve this case? Is he able to resolve this case? Looks like on the CF case, he may have been placed on conditional release. Can we look up 2021 CF 1140?
Talking about somebody else.
Your Honor, I believe the offer from the state is a withhold credit time served, for the disorderly conduct. I would just ask that because he's resolving this case, that you take no action on the payment.
I just want to look to make sure he's not out on conditional release, because that would mean that he's not competent to proceed.
Oh, okay.
There's nothing? Have they filed on it?
It's blank, there's not even that. Do you guys have a charging affidavit from this?
I didn't see anything. And let me just double check.
I have affidavit.
It's not a charging affidavit.
Just here for disorder.
No, just calm down. Oh, no, I don't even have them in my system, Your Honor.
Thank you. Oh, this is a different person. This is somebody else. This is Mencia Perea. This is the case.
I'll get it for you.
Yeah. No, that's this one. I have that. What I don't have is the one on this case. This one. There's nothing, no information on that.
Yeah, I didn't see any, all his old cases, Your Honor, that we've had with him have resolved with him taking a plea. As far as the petty theft, I don't see that case in our system. I don't know if we were appointed, if it hasn't been opened yet. I don't see anything.
All right, Mr. Davis, while we're figuring that out, is that my understanding that you want to resolve your case today?
Absolutely.
All right,
I'm sorry, yeah. It was an entry error. It is closed.
okay. All right, so there's no open case. Okay.
All right.
And Mr. Davis, are you thinking clearly today?
Absolutely.
Are you under the influence of any drugs, alcohol, or medication?
Yes, Your Honor.
Are you under the influence of any drugs, alcohol, or medication?
Sorry about, no, Your Honor.
Okay. Are you suffering from any mental illness or emotional disturbance?
No, Your Honor.
Have you had enough time to discuss this decision with your attorney?
Yes, I have.
How far did you go in school?
12th grade and beyond,
And do you read and write in English?
and other languages also.
All right, but in English?
Yes,
Okay. And did you have an opportunity to read and review the plea form?
yes, I did.
And do you understand the constitutional rights contained in the plea form?
Yes,
Do you understand that by entering this plea, you're giving up those constitutional rights?
yes,
And do you understand that by entering this plea, there will be no trial, and I will impose sentence based upon the plea agreement?
yes, Your Honor.
All right. As to the charge of disorderly conduct, a city ordinance, how do you plea?
No contest.
And are you entering that plea because you believe it is in your best interest?
At this time, yes, Your Honor.
Is anybody forcing you or threatening you to get you to enter this plea?
Not at all.
Is anybody promising you anything other than what your attorney has announced here today to get you to enter this plea?
No, sir.
All right. Do you understand that if you are not a U.S. citizen, that entry of this plea would result in deportation?
Yes, I understand that.
And do you understand that if you were pleading to a sexually motivated or sexually violent offense, or if you've been previously convicted of any such offense, that entry of this plea could result in involuntary civil commitment as a sexually violent offender upon completion of your sentence?
Yes, Your Honor.
All right. I do find that you are alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges and have had the opportunity to consult with competent counsel. I do find that there's a factual basis based on the affidavit submitted by Officer Vernon Early. So I will proceed with sentencing. As to count one, the court will, it was an adjudication? I'm sorry. I will withhold adjudication, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. I will impose court costs. Those court costs will be reduced to a civil judgment. Mr. Davis, you have the right to appeal the judgment and sentence of this court. Any notice of appeal must be filed in writing. It must be filed within 30 days of today's date. If you cannot afford an attorney for purposes of appeal, one will be appointed to you at no cost. All right, thank you, sir.
I apologize, and I appreciate y'all.
No worries. All right, Caleb Moncrieff. Caleb Moncrieff. 210-10274.
Oh, Portuguese?
Caleb Moncrieff. Oh, 210-10274. All right, he bonded out. Maurice Morgan.
Bonded, Your Honor.
All right, I think that's everybody.
We have a Portuguese.
Is there anybody else?
Still, I want a Portuguese,
Oh, the Portuguese, okay.
On that one. I already sent out copies.
It was in the beginning. What happened? They didn't-
Portuguese.
The LP. And May.
Yeah.
All right.
It's the language.
Interpreter, can you hear me?
hello?
Hello? All right, Mr. Mr. and Miss Interpreter, can you hear me?
Yes.
All right. Madam Interpreter, we're here on the case of Rogelio Lema. Mr. Lema, you are charged with battery domestic violence.
Olá, eu sou a intérprete desta chamada, vou traduzir a vossa conversa. Esta chamada, o senhor está a ser acusado de agressão e violência doméstica.
I'm going to appoint the public defender to represent you.
Eu vou escolher defensor público para representá-lo.
Okay.
As to the charge of battery domestic violence, I do find that there's probable cause.
Depois da acusação de agressão e violência doméstica, eu concluo que houve causa provável.
Defense, with regards to release, Mr. Lema qualifies for PTR.
Em relação à libertação, o Sr. Lima qualifica para PTR.
Your Honor, I would just ask that you place my client on pretrial release as he does qualify.
Sorry, desculpa, não entendi.
I'm sorry, I didn't understand.
Can you repeat that?
Yes. Since my client does qualify for pretrial release, I would ask the court to place him on pretrial release, being that he qualifies.
Uma vez que o senhor se qualifica para a libertação anterior ao tribunal, ao julgamento, eu pedia que fosse então libertado anteriormente ao julgamento, já que qualifica para isso.
Qualifica para o quê?
Para ser liberado antes do julgamento.
Ok, gracias.
All right, Mr. Lima, I'm going to grant that request. I will release you on pretrial release with the following conditions.
Yes, em português.
Estou aqui para traduzir, obrigada, não precisa de me dizer. O senhor tem de, portanto, uma vez que vamos liberá-lo antes do julgamento, Vamos fazê-lo com as seguintes condições.
You are not to have any contact with the victim.
Não pode ter nenhum contato com a vítima.
You need to maintain a separate residence.
Yes.
Precisa de manter uma residência separada.
I will allow you a one-time return to the residence
Sim.
if accompanied by law enforcement.
Ok.
O senhor pode ir regressar uma vez apenas à residência, acompanhado de policiais da lei.
To pick up any personal property.
Estou liberado?
O senhor tem de ouvir. O senhor pode aceder à residência uma vez com acompanhamento da polícia. This is the interpreter speaking. Would you mind repeating, because he just keeps saying he just keeps asking if he's free now.
Okay, so I'm going to answer his question. You will be released once you're done being processed by pretrial release.
O senhor será liberado depois de acabar o processamento para a liberação anterior ao julgamento.
But I need to make sure that you understand the conditions of that release.
Mas eu preciso ter a certeza que o senhor compreende as condições dessa liberação.
Sim, que não posso estar perto.
So as I stated before, that means no contact with the victim, maintain a separate residence, and you will be allowed to return to the residence to pick up personal belongings if you're accompanied by law enforcement.
As condições são: não pode manter contato com a vítima, tem de ter uma residência separada e pode voltar uma vez apenas à residência para ir buscar os seus pertences, acompanhado de polícia.
You are also not to possess any weapons or firearms.
Ok.
Também não pode possuir nenhuma arma ou pistola.
No, no arm.
All right, thank you, sir.
Thank you.
All right, thank you, Madam Interpreter.
My pleasure. Would that be all for the interpreter, Your Honor?
That is all.
Thank you for using our services. Goodbye.
Yes.
One for the record. Daniel Masilla Figueroa, he was placed on pretrial release, but he lives out of state. If you can grant permission for him to come back to Illinois.
Let me have the case number. I'll just recall it on the record. All right, recalling Daniel Mancia Pereira. Yeah, I think case number.
I'll put the case number on.
All right.
It's 2021 CF 5040.
All right, court will allow him to return to what state?
Illinois.
To Illinois. All right. All right, that concludes first appearances. Thank you, everyone.